ask is not there, save for the OB extracts.
Just don't move. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Then why are you putting in the first place?
Yeah.
The question is, why are you putting in the first place?
You can put it there. You can put it all over.
Really went to law school.
So that's if you know what answers, those questions that you're putting,
I
you're
know.
putting a lot of putting in.
Yes.
Yona, we have our own label here. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the OCS left the police station and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has had its own. Let's go, paragraph 15. On the question of him likely to plan. You there?
Yes.
We have agreed there is no any material.
Yes, nothing
Thank you.
attached. to
Let's
this.
proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you paragraph
15.
15.
Yes.
I'm going to paragraph 16, sorry.
Okay.
Still no material attacked. It's either very serious material you have kept, no material attacked.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17.
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not. It's not in my affidavit.
You've run very fast. You cannot lie that is it. So you cannot. There's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same.
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. Which this is a lawyer. He knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He'll face you over that matter.
It's okay.
He's the one who argued that matter. Cliff will deal with the blue coat. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
Avoid recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because counsel, you know very well, the authorities, the Sagari, Duat Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your violence?
Nothing attached.
Thank you. Important. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the gruesome murder of the deceased has elicited widespread public anger. And therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not in my affidavit.
No. You will fail to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
what
in my
do you specifically want him to do?
All I have stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Surely.
Waiting, allow
Sorry,
me.
no. Yona, where is the provision that does not allow you? Surely.
Where is
You
the
are asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and council can put it. He can continue putting it to him that this provision does not allow you, not the negative provision.
Maybe rephrase your question, Mr.
I'm rephrasing. You know, which has a problem is preparing for the judge. It's not akin to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specific. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your varmints are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, should the court why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent